Welcome back, DeDe. Today, we're going to talk about legal guardianship plans and how to protect your children with them in California. Um, Most young parents may think that like having a will is enough to protect their kids if something happens to the parents. Why is that not actually true?
That's a great question. Thank you. So it's not true because in a will, many times people will name a guardian and who would raise their kids should something, the unthinkable happen to the parents. And then, so let's just kind of divide it up into two categories. We have custodial of the person and then the custody of the estate, the finances. So naming guardians in your will for custodial purposes and financial purposes will actually trigger probate and a legal process of guardianship in the state of California.
So, if something happened, like just go into real detail here. If something happened tomorrow to both parents,
Yes.
and there were no legal guardianship documents in place, can you walk us through what would actually happen to their children in those first hours and days?
Certainly. So initially, we don't know who would be the next of kin. We don't know who is supposed to raise the kids. So here in California, I think throughout the United States, actually, Child Protective Services would be called. And that would be similar if mom and dad were driving down the street, they got in a car accident and they were both, deceased, and the minor children are sitting in the back of the car, right? The police, the fire, they immediately call Child Protective Services. Child Protective Services comes in and picks up the children, right? And granted, it's foster care. There could be some great people that are serving as temporary foster, but you don't know, right? You just don't know who it is because Child Protective Services does step in and the children are detained until something can be figured out. And that something would be maybe it's a family member going to court on an emergency and getting a temporary guardianship so that they could take physical custody of the minor children. Then, if that was granted, right, or there could be competing, maybe both sides of the family, it could be, brothers and sisters, the aunts and uncles stepping in. It could be both grandparents, right? You don't know. They could actually battle it out, believe it or not. And we've had those instances where mom's family and dad's family was fighting over who was going to raise the minor child. And so then that's a long court drawn out. So the court could appoint a temporary, or they could keep them in child protective services until it gets resolved. Then once you got the temporary guardianship, then the court would set a permanent guardianship. And that's where they would have a guardian ad litem. They would have a court investigator that would come out to the houses and they would evaluate. They have to write a report, and then the judge has to see the report. Whomever is coming forward, whether it's the godparents, the actual grandparents, the aunts and uncles, they have to have a court investigator, and then this guardian ad litem that's appointed to represent the minor child. Depending on how old the minor child is, they will actually ask the minor, "Are you okay with living in this situation? Are you okay with these people raising you?" So if they have a voice, of course, they will ask. If they need another room addition, if who knows what the circumstances are, but the court investigator writes a report to the guardian ad litem. The guardian ad litem actually writes a report too, as well, based on the evaluation of whomever is coming forward. So there is no necessarily um, a right of sort of first refusal, if you will, to be the guardians, right? So it would be, and it's usually the next of kin, but many times, maybe grandparents are older. Maybe there's, no aunts and uncles. And maybe you would actually want a friend to be the guardian that's appointed for your children if you were unable to raise them. Well, they would not be considered, right? They would have to go through the same process as well. And so that's when I think it's very important to actually name guardians. But that's the process here in California. And that could take up to 6 months. It could, especially if grandparents are battling over who's going to raise, each
Mhm.
side, um, and the competency and the availability as well.
Yeah.
Then the funds, that's a whole different story, right? Guardian of the estate, let's say there was a life insurance that was left. It could have been $1 million life insurance that actually named the minor, then that triggers probate and a guardianship of the estate because a minor cannot receive assets, right? So you have to go through the probate process. Then, once you go through the probate process, then it will flow into a guardianship of the estate of the child. But all they're doing is holding the funds until that child turns 18. And it's a public process. And while they're a minor, it's kept quiet, so to speak, but they really don't have access to these funds. It's held with the state of California. Many times they'll put it in a blocked account. And because the idea is that is the minor's money. And in order for the guardian to use it, they really have to show cause if they needed to use the funds. And so it is a difficult process to pull out money once it's been designated into the estate. And what's kind of unique also, we've had these issues come up where maybe the guardian literally wants to invest the money, but the court's position is they don't want the money to be lost. So if you're putting it in the S&P and the stock market, they don't approve of it, right? They want something that's locked in, secure, that when this child turns 18, that $1 million will be there, or hopefully it's
Mhm.
grown a little bit, but you can't put it in, you can put it in a high yield savings account or a CD, but things that are very secure.
So let's talk about a legal guardianship plan and what it actually is. Just really succinctly, really clearly define what is a child protection plan and how is it different from just naming a guardian in your will?
Well, as I said earlier, in many states, you just name the guardian in your will, and that only happens when does that happen? When you die. But there's a whole lot that can happen before. So our child protection plan is naming short-term guardians and long-term guardians. And in the state of California, you can actually name guardians outside of your will. And this goes back to, there's no need to procrastinate because you can change this as many times as you want. So it's a legal writing and your short-term guardians, our magic number is 3. I know you've heard me talk about 3 in the past, but short-term guardians, if something happened to you in the short term, you're going to live, but you get in a car accident and you're rushed to the hospital, who's going to take care of your minor children? And that's where the short-term guardian comes in. We always say it's nice to have someone that lives within 20 to 30 minutes that even if Child Protective Services was called, they could go to Child Protective Services, show them the legal document that says, Mom and Dad gave me the legal authority to take physical custody of these minor children. And so, again, first choice, second choice, third choice is always nice because maybe someone's out of town, maybe someone is sick, right? And they cannot go and pick up the children, the minor children, if something happened to mom and dad. So that's the short term. And then the long-term guardian, it's similar to naming them in a will, but it's an outside writing that has been signed and witnessed, just like a will has to be witnessed. This is witnessed by for the parents to say, okay, if something happens to me, mom and dad, because it always goes to mom or dad, it's just in case something happens to both parents, then these are the people that I would like to have physical custody. And physical custody, again, is someone that is raising your children the way that you would want them to be raised with the same morals, the same values. Maybe it's the same religious values. Maybe it's the same economical, social status. It doesn't matter who you name, but you have to name someone that is going to be caring and loving. And that's the custodial. And then the estate is someone that's managing the finances. And they can be different because if someone is managing the finances, then the custodial guardian would just go to the estate guardian and say, you know what? Here's the cost, right? Maybe they're in private school, they need, uniforms. And so in the month of September, they need to have $5,000. And then the estate guardian would pay that to the custodial guardian. And so It's the custodial guardian and the estate guardian, but by naming them in your child protection plan, you have both and you're protected in case something happens. You're protected in the short term, and then if the unthinkable happen, you're also protected in the long term from the custodial angle and the estate angle. But there is no automation just because you have godparents, they're not automatically named as the legal guardians.